Welcome to the deep dive. Today, we're stepping into the Australian workplace. And it's a place that, often looks simple on paper.
Right, a contract, a salary, that's it.
Exactly. But in reality, it's this dense web of rights and responsibilities and, of course, disputes. And for a lot of employees trying to navigate that system, especially when you're facing unfair treatment, it can feel impossible.
It absolutely can. And our source material today, it gives us this really critical look at that landscape. We're not just looking at the types of disputes that pop up all the time.
Like unjust firings and toxic environments.
Exactly. But we're also focusing on the highly specialized support structures that are actually available to the Australian workforce.
And this is key. We're also charting how the system itself is evolving. We've got these fascinating recent examples from the Fair Work Commission, or the FWC, that show how it's actively trying to tackle language barriers for non-English speakers. Plus, we're going to get into the really serious legislative crackdown that's happening right now against wage theft, which so often targets Australia's most vulnerable migrant workers.
Yeah, it's a deep dive into these sort of dual tracks of accessing justice. You've got the private sector specialists helping people fight their case on one side.
And on the other?
And on the other, you have the regulatory bodies using these powerful new laws to set massive corporate precedents.
Okay, let's unpack this. The sheer demand for expert help really tells you something about the volume and, frankly, the complexity of the issues that Australian workers are facing.
It really does.
I mean, we're seeing specialist services in our material that have been supporting employees for over 30 years. They're available 7 days a week in some cases. It just underscores that, when you're dealing with the Fair Work Act, going it alone is probably not the best move.
No, rarely the strategic one. And when we talk about that kind of specialized support, we have to look past the sort of surface level stuff. The primary service is, of course, unfair dismissal. That's where an employee is challenging a termination that was either unjust or didn't have a valid reason, or maybe just lacked the proper formal protocol. The goal there is pretty clear.
Get a fair financial outcome or maybe even get your job back.
Exactly. Secure a fair payout or, where it's possible, reinstatement.
But the whole strategy, it gets way more complicated when you move into those areas where the employer is targeting someone for, doing something right.
Or for exercising a legal protection.
That's it. And that brings us to general protection disputes.
And that distinction is just so crucial for you to grasp. While unfair dismissal is all about the fairness of the termination itself, a general protections claim, that's about adverse action.
Meaning punishment.
Punishment, yeah, taken against an employee for exercising a fundamental workplace right.
Okay, so ground that for us. What does adverse action actually look like in practice?
It could be something like being demoted, having your hours deliberately cut, or even being dismissed.
Just for exercising a right.
Purely for that. Like filing a complaint about safety, or taking parental leave that you're legally entitled to, or participating in lawful union activity. These disputes, they're inherently more complex. They require a really deep understanding of litigation strategy, because you often have to prove the employer's underlying intent.
And that's a huge burden of proof, which I guess explains why employees need this level of dedicated representation.
It really does.
Then you have the less obvious disputes, the ones that are just as damaging, like when an employee is basically forced to quit.
That's constructive dismissal. It's often linked to a toxic workplace environment. The sources we looked at, they really highlight that compelling an employee to resign because of intolerable working conditions is just fundamentally unlawful.
So these specialists are focusing on those cases.
Yes, cases where the environment, maybe it's driven by bullying or sexual harassment, is just so damaging that it amounts to a forced resignation. The impact on an employee's mental and physical health in those situations is, it's often severe.
So they structure the case around that.
Right, around recovering damages and getting justice for those unlawful actions.
So why use these specialized non-lawyer workplace relations representatives? A lot of them offer a no-win, no-fee option for things like unfair dismissal and sexual harassment. What's the strategic benefit there compared to, say, a traditional law firm?
I think the benefit really boils down to specialization, cost management, and often speed. These representatives, they focus solely on the fair work system.
So they know it inside and out.
Deeply entrenched in the mediation and arbitration processes of the FWC, yeah. Traditional law firms, they often charge by the hour, no matter what the outcome is.
Right.
That no-win, no-fee model is actually really insightful. It's not just about affordability. It's a shared risk model. It shows they're confident they can get a good settlement or outcome in those high-probability claims. They're strategic negotiators looking for an efficient resolution.
It sounds like they're really focused on avoiding those long, expensive court battles, and they prefer to resolve things through negotiation and arbitration where they can.
That's the goal.
Which makes a lot of sense, especially for employees who are already under huge financial stress after losing a job.
Precisely. They're aiming for, seamless management of the case.
Right.
They know the FWC system intimately, which often just speeds the whole process up compared to trying to navigate that complex bureaucracy all on your own.
Okay, here's where it gets really interesting. Because if we're talking about employees being able to access justice, to navigate these complex procedures, we have to acknowledge that Australia's workforce is incredibly diverse.
Incredibly.
Nearly a third of our population, I think it was 31.5% as of mid-2024, was born overseas. And that translates directly into the workplace.
It does. And that diversity means the system has to adapt, especially to language barriers. And our sources show the FWC is actually doing just that.
This is a really powerful example of the Fair Work Commission evolving its idea of what procedural fairness actually means.
A powerful demonstration, yes. We can look directly at the case of Mr. Alam Shah versus Real Dairy Production. It's from 2025. This case just perfectly highlights how severely linguistic and cultural issues can make a complex dismissal situation so much worse.
So tell us about Mr. Shah's situation.
Okay, so Mr. Shah is an Australian citizen of Rohingya descent. The commission specifically noted he had, and I'm quoting here, poor English proficiency. And beyond that, his personal circumstances were just profound.
He was supporting family back home.
He was financially supporting his family, who were living in a refugee camp in Bangladesh. His dismissal, it came after some alleged aggressive conduct and a workplace injury, and the termination was just delivered to him summarily via email.
Wow. And the source material suggests the employer, Real Dairy, they really struggled to back up their decision.
They presented very weak evidence. They relied on unsigned statements, vague assertions. They completely failed to prove that his conduct actually warranted a summary dismissal. But the pivotal legal mistake
Was procedural.
It was procedural. The FWC found that Real Dairy failed to properly notify Mr. Shah of the precise reason he was being sacked. And critically, they didn't give him a meaningful chance to respond before they finalized the termination. That is a classic denial of procedural fairness.
And the FWC didn't just say the procedure was flawed, they connected it directly to his background.
Absolutely. The commission gave significant weight to his personal circumstances. They acknowledged that his language and cultural issues, as they put it, just amplified the distress and the confusion from the employer's terrible handling of the whole thing.
So they essentially said the employer had a higher duty of care.
They ruled Real Dairy had a heightened obligation to ensure there was clarity and proper communication, which they completely failed to meet.
The outcome was a win for Mr. Shah. He was reinstated, awarded over $18,000 in lost pay. But the real insight for us, the thing that stands out, is what the FWC did next with the decision itself.
That is the precedent-setting move. Because of the workers' known difficulty with English, the Fair Work Commission took this extraordinary and I think crucial step of translating its entire written decision into the Rohingya language.
That's not just an administrative courtesy?
Not at all. This reinforces the principle that procedural fairness doesn't just mean handing someone a document. It means ensuring the employee actually comprehends the reasons for the action and understands the commission's ruling. It actively expands the definition of fairness to include linguistic accessibility.
That sets a very strong benchmark. So if we're seeing regulatory bodies adapting to ensure linguistic fairness in dismissal cases, we need to shift our focus to the other major challenge: active, systematic exploitation. We're talking wage theft against vulnerable visa holders.
And this demographic is just acutely vulnerable, especially international students. The source material notes that students are the second largest group of temporary visa holders in Australia.
And a lot of them work, right?
About 61% of them work while they study. They rely so heavily on that income, which just makes them such easy targets for exploitation.
And this Chatime underpayment case is just a textbook example of that kind of systematic exploitation.
It is. The bubble tea chain and its director, they face some serious penalties.
Yeah.
We're talking $132,840 in fines.
And this was for underpaying a lot of people.
More than 150 employees, mostly international students and junior staff, and this was between 2016 and 2017.
And the scale of it was just alarming. They were paid these flat rates that were just grossly below the legal minimum.
Paid as low as $7.59 an hour in some cases. They systematically sidestepped all the mandatory entitlements under the fast food industry award. The total underpayment was over $162,000. It wasn't an accident.
It was a business model.
It was a deliberate strategy to maximize profits at the expense of vulnerable workers.
And what makes this group so susceptible is the fear around their visa status.
That is the absolute core of the vulnerability. The sources highlight that many of the affected visa holders, a lot of them from countries like China and Taiwan, they were terrified to speak up.
Why?
They were led to believe, or they just legitimately feared, that if they reported the wage theft, they might be the ones investigated and deported for, a perceived violation of their visa conditions.
Even if their employer was the one pushing them to work too many hours.
Exactly. And employers knowingly capitalize on that really precarious position.
So when the company tried to downplay this in court, how did the Federal Circuit and Family Court react?
The court was unambiguous. They completely rejected the company's argument that the underpayment was minor. The company tried to frame it as, just over $1,000 per employee.
Which is still a lot of money to a student.
A huge amount. And the court countered forcefully. They said the penalties must be significant enough to set a signal to corporate leaders everywhere about the seriousness of denying basic entitlements to a large number of vulnerable employees.
This signals a massive escalation in enforcement. So what are the regulatory bodies, like the Fair Work Ombudsman, what are they doing now?
The FWO is deploying much more aggressive and targeted strategies. They've already secured nearly $23 million in penalties in cases involving visa holder workers just over the last 7 financial years.
Yeah.
But the enforcement has now gone interagency.
You're talking about those joint inspections.
Yes. The FWO is now conducting joint unannounced inspections with the Australian Border Force. We saw this in the February 2025 operations in Melbourne.
And they're targeting specific industries.
Specifically targeting businesses in high-risk sectors. Fast food, retail, manufacturing, places known to employ large numbers of temporary and migrant workers.
And this collaboration, it's tied directly to some powerful new laws.
That is the essential context here. These inspections are making sure businesses are complying with the Migration Amendment Act, which kicked in back in July 2024. This legislation, it's a paradigm shift.
How so?
It introduces serious criminal penalties. We're talking fines up to almost $119,000 or 2 years jail time for employers who exploit a person's immigration status. Wage exploitation of visa holders is no longer just a civil issue.
It's now a potential criminal offense.
A potentially criminal offense, exactly.
That sends an incredibly clear message that this kind of corporate exploitation will not be tolerated, and the consequences could now include jail time for directors.
It raises the stakes significantly. It gives the FWO the legislative teeth it needs to dismantle these business models that are built on exploiting the fear of temporary visa holders.
So what does this all mean for the Australian workforce and the system that's supposed to protect it?
It means we're seeing this dual evolution in access to justice. On one hand, you have these specialized non-lawyer representatives filling a critical gap. They're offering strategic, cost-effective representation in these complex disputes, from unfair dismissal to constructive dismissal.
And on the other hand,
the regulatory bodies are pushing the boundaries of what procedural fairness means, literally translating decisions to make sure people understand. And they're introducing these severe criminal deterrents to protect the most vulnerable workers from systematic wage theft.
so the knowledge we've gained today really emphasizes that fairness in the Australian workplace, it relies on both that strategic representation and active regulatory intervention. It's making sure that justice goes beyond just legal formalities and extends to linguistic and cultural comprehension.
I think the biggest takeaway here is that fairness in the Australian workplace is increasingly relying not just on the letter of the law, but on the ability of every single employee, no matter their background or their English proficiency, to access clear information and get proper representation.
The source material, it highlights this deep complexity that's just embedded in Australian employment law. It references cases that discuss the challenge of even defining who an employee is, like that contentious Anglican priest case, or the difficulty in distinguishing between an unfair dismissal claim and a general protections claim, which is often much more complex. So this raises an important question for you, our listener. If the very definition of who even counts as an employee is becoming so nuanced and so difficult to determine, does the average Australian worker now need expert guidance just to understand their own employment status and what their specific rights are before they even start day one on the job? That's the kind of complex preparation that the modern employment landscape seems to demand.